I now call the first case on this morning's docket. Case number 116505, State of Kansas v. Christopher Boothby.
May it please the court, counsel. May I have 3 minutes for a vote, please?
3 minutes is granted.
Thank you very much. Mr. Boothby he was driving his truck, went to his cousin's place of business, and he had a gun in his lap. The cousin approached his truck and said, "What are you doing here?" The cousin reached in, they struggled for the gun, and then Mr. Boothby drove away. He was eventually convicted of aggravated assault and criminal threat. And he was also, prior to going out to the cousin's workplace, he drove to the cousin's house and went into the house. And he was charged with aggravated burglary, although those charges were, the judge dismissed those charges. But before trial, the judge said to the jury, Mr. Boothby's been charged with aggravated battery and aggravated assault. And I believe it was the prosecutor correct and said, no, it's aggravated burglary. And the judge said, oh, I'm thinking about this other case. And this was in front of, they had 2 juror panels. This was in front of half of the prospective jurors. And so they said, oh, let's start over. He's charged with aggravated battery and aggravated burglary and aggravated assault. And I knew I was going to do that. And then, so we raised the issue of whether that was judicial misconduct, whether that prejudiced Mr. Boothby. We also raised an issue. The jury was instructed that its verdict must be founded entirely on the facts and the instructions as given in this case. And we argued that was a legally inappropriate instruction because it did not inform the jury, because it informed the jury that they couldn't nullify, essentially. I'm here at the court's pleasure, and I'll talk about whichever issue the court would like to talk about. Personally, I think the nullification issue is more ripe for discussion, and so I think I'll focus my remarks on this, although if the court has any questions, I'll be happy to answer them on the first issue as well. The one thing I think is interesting about the nullification issue is, well, a lot of times we stand up here and the state, we disagree on sort of the finer points of what happened, the finer points of the law. And here we have a fundamental disagreement about, it's called jury nullification, about whether it is a good thing or whether it is a bad thing in the system. I believe the state called it inherently lawless in its brief, and courts back that up. And I think that this jury nullification, which is the ability of the jury to acquit, even in the face of facts or when the facts meet the law, and the jury believes the defendant has committed the crime. Facts support, yes.
So you would define it, jury nullification, as, at least in one instance, deciding a case contrary to the instructions on the law. Because it would be contrary to the law.
Can I say it that it would be where the jury finds that the facts meet the elements of the crime? That
where I'm having problem with the logic here, that you want an instruction that doesn't set forth a rule of law because the jury is allowed to nullify that law. And it seems to me you can't have jury nullification unless you have a rule of law or you have something that they have to nullify. And if you're going to put it here in language that's discretionary, then you're giving them the discretion, and that's not a nullification. I mean, I don't understand how you can call it nullification if it's instructed to be a discretionary point. You understand what I'm trying to ask you?
I understand what you're saying. I think there are 2 points, and I hope I can remember both of them. The first of it is that what they're finding contrary to is the elements of instruction and the idea that they're being convicted. I don't know that you need an instruction. You give the law, here are the elements of the crime. Here are how you should consider the witnesses. all of the preliminary instructions. I'm not sure you need an instruction at the end that says, oh, and so this is what you should do. That's sort of obvious. If you're baking a mix of brownies that says, put it in the oven for 350 degrees, you don't need an instruction that says this is how you make brownies, because that's the jurors understand that's what you have to do. And I think go ahead.
Well, the instruction is your verdict must be founded entirely upon the evidence admitted and the law is given in these instructions. That's the law. And when I defended criminal defendants, I wanted that law followed. I didn't want the jury to find the defendant guilty based on evidence that wasn't admitted. And I don't understand why that isn't the foundation of the whole system, that statement.
Well, because the foundation of the right to jury is, I mean, that's part of it, right? Is that we want the jurors to follow the law. And I think jurors want to follow the law. They want to do the right thing.
Isn't it more than that? I mean, the statutory oath for the jurors is that you will follow the law and make sure, basically, this instruction repeats the oath of the juror.
I think that may be right. In which case, I think the oath is wrong.
6247, jurors must swear or affirm to try the case conscientiously and return a verdict according to the law and the evidence.
But then I think the oath doesn't reflect the right of the jurors to decide the case.
You haven't made a statutory attack, have you, on the oath?
I've not made a statutory attack on the oath.
And so what can be wrong with an instruction that basically repeats a statute that you haven't attacked? How do you get there without that?
Well,
I mean, if nothing else, on harmlessness. They've already taken an oath to do the same thing.
I guess I don't know if I haven't attacked the statute. I'm not sure if the instruction is consistent with a statute and it's inconsistent with the constitutional right to a jury trial, then it seems to me that would not be harmless. It would still be the constitutional, even if I didn't attack.
You're saying even if the instruction is legally inappropriate, then so is the oath. You don't have to attack the oath. If it's legally inappropriate, it's legally inappropriate.
I would think that. Yeah, I think that's right, because it's constitutional. That's right. That's what I would say. And
What's your alternative language? I mean, earlier you said they don't have to get any instruction. Is
well,
that your alternative?
I mean, I didn't mean in instruction at all. I don't know that they need an instruction at the end to say you need to follow these instructions. I think that is inherently.
Well, what should they be told if this is wrong?
They need to be told the elements of the instruction, that this is, this is what constitutes.
Sort of follow up on Justice Johnson's question. What, in the absence of this kind of instruction, prevents a jury from considering factors that they shouldn't consider when rendering their verdict? Factors that are outside the law or the evidence.
I don't know.
Isn't that a problem for lots of defendants?
Well, I don't know. I don't know that instructing the jurors that they give them the instructions that they would necessarily then consider. We have been told we can't consider that he's a divorced man, so I'm going to consider that. I don't know that that this is the instruction that cures that. That I think jurors, it seems to me that jurors want to do the right thing. And if they're going to make those determinations, they're going to do it. And I understand. And I think I've talked to defense counsel who share, I think it's like, oh, well, we kind of like this instruction sometimes. And I suppose maybe, I don't know if they can request it then, or I don't know. But it just seems to me that the instruction as it is legally inappropriate. And there may be reasons for it, but it is an incorrect statement of the law that the jurors must found their verdict entirely on the evidence and the instructions.
It doesn't use the word must, though, does it?
I thought it used. Does it not use the word must? I thought it said your verdict must be founded entirely on this verdict. I thought that's what it said. Let me double check that. But that's what I thought. Or maybe it says shall.
The instruction given here was must.
Must. Okay.
I'm sorry.
No, that's all right.
I was
That's all right.
reading the language you were proposing, which was should, I think, right?
I put should in there, yeah. And then
I'm sorry.
I think a should. I know there are other arguments out there on this that also that don't like should. That we don't need to be informing the jurors one way or the other.
But
It's
not to be a broken record, to flip it on the converse side, should implies discretion, and there is no discretion to convict someone on evidence that hadn't been admitted. I mean, that's because you'd argue up here sufficiency of the evidence.
Sure. Yes.
And so, why shouldn't the jury be told that they can't, and I can't think of an example right now, but there are some times when the factual scenario places the defendant as the bad guy wearing the black hat,
Yep.
but the elements of the crime are not there. And so in that instance, they have to be told just the evidence and just the elements,
Before
just
we
the
define- yeah,
law.
sure.
And just because they got away with something else or they profited, I mean that's pretty fundamental that you have to tell them that from that side. And how do you make certain that the defendant is protected with your discretionary instruction from the state standpoint?
Sure. Well, I guess I don't know, Your Honor, and I guess the question is, do we? You have two contrary problems. I understand the concern of protecting the defendant, but there's also the concern that the defendant is being harmed, or not even the defendant, but that the jurors are not being allowed to use their discretion. And I think it is certainly, I think it is, nullification is kind of an odd word. I think there is discretion in jurors not to convict. That we have given them that power. And I think that's within their discretion. And how you balance those.
Isn't it an extra legal check on the power of the state to prosecute and convict somebody?
Yeah, I'm not sure.
I mean, that's inherent in the very word.
The nullification, you
And
know?
it's an extra legal. It's something that can happen in our system, but it lies outside the law.
I guess I would disagree with that. I think it's very much within the power that we give the juries, because we don't have special verdicts. We don't have jurors just find facts and apply
So
them.
you would be in favor then of an instruction that said you have the right to ignore the evidence in the law and return a not guilty verdict, because
well-
that's something that's
I
within the law.
Maybe we'll be back talking about that. I don't see that that's a bad thing, and maybe that's the answer to the question, is that you specifically say, if this is what we're talking about, if we're going to narrowly do this, then bring Naputi, which I think, as this court said, that you don't give that instruction. You don't affirmatively tell the jury that maybe that's the way that you can say that you have this right. Otherwise, you must follow the law.
Let me move you over to the burden of proof on the judicial misconduct issue. As I understand our current case law, the defendant bears the burden to show that you were harmed by what the judge did in this case. But you want the burden to shift over because the state was the beneficiary of the error. Just real quickly explain why we should overturn our existing case law in order to shift that burden over to the state.
Well, I would rely heavily on McCullough, which is where this court considered generally how error is, and the idea that the party who benefits from the error bears the burden as they have. And part of the problem is that if you require different burdens, because we already have McCullough, if you require different burdens, then you have a cumulative error problem where you have different, one party bears the burden on one part, one party bears the burden on the other. I guess generally, I hate to say it up and say it's fairness, but to me I look at it like this. The question is, we're telling a defendant, the judge committed misconduct in this case, and we're not sure whether it denied you a right to a fair trial. And the answer is, so then we tell him, and you don't get a new trial. Or do we say, we don't know whether you got a fair trial or not because of this error, so you get a new trial. If we don't know whether you got a fair trial, then it seems to me we could do that. And also, we talked a little bit, I think, that
Well,
the
you're
state...
moving over to structural error then, aren't you? I'm just talking about the burden of proof here.
Sure, yeah. Well, no, I think if we don't know, I'm saying if we don't know whether the error, the state can prove that the error was harmless, then, the judge committed this mistake, but the court found that the state proved that it's harmless. But if we don't know, if neither party can say one way or the other, we don't know whether it was error or not. We don't know whether it was misconduct, whether it was reversible, whether it was harmless, whether it denied you a fair trial, then he should get a new trial. Additionally, may I make one more point, Your Honor?
Yes.
The state brought up the idea of changing it to, because this wasn't objected to, they brought it to the judge's attention, but the specific error wasn't mentioned, that the party, if it's not raised below, we should do like the federal system does, and you do plain error, and the party asserting plain error has the burden of proving harmlessness. And I think if you point out in our response to that, if you look at the language that the federal courts rely on, it is that their harmless error on when it's raised says that it does not affect substantial error, which they have said if the question is it does not affect substantial error, then the state bears the burden of proving that it did not affect special error, as opposed to if the plain error statute says if it affects error, in which case the party asserting the error has to show that it affected the substantial rights. And so I think that reasoning is solid as well.
Just so I'm clear, counsel, you're asking us to hold that in a case like this, the defendant has no obligation to object at the trial court level and then raise error on appeal. And if we find error, then the burden shifts to the state to prove it was harmless.
That's exactly what I'm asking, Your Honor. And I think that is consistent with, other than your evidentiary cases, which are specifically based on a statute, on evidence and how harmless error is considered in those cases, I think that is consistent with other types of error.
We usually apply the 3 exceptions to why an issue should be raised for the first time on appeal. Where does this fit in those exceptions?
Well, I believe that it would fit within the fundamental rights and denial of the fundamental rights, in that if the judge is committing misconduct, I believe this court has said that affects the neutral magistrate requirement that you have a right, your right to a trial, to a jury trial. So I believe it would fall into that exception.
Any further questions? Thank you, counsel.
Thank you.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. I'm going to address the issues in the opposite order that was addressed by the appellant. On the judicial misconduct, there's no reason for this court to overrule its longstanding precedent on the error in standard in judicial misconduct. To the extent that this court is trying to look for a statutory ground to have the different rules of harmless error, first, 6404 requires an objection to then get to 6261, which is the harmless error standard the appellant wants to use. But there's also another harmless error standard. There's 62105, and that one has slightly different language. So you could burden shift based on that. It says, which do not affirmatively appear to have prejudicially affected the substantial rights of the party. Regardless, there's absolutely no constitutional requirement that the state should be required to prove unpreserved error is harmless. We know this because the federal courts do not require that. They use the federal plain error standard. And there are important reasons to require objections, or else there's pretty much no incentive to object. If there's no requirement of objection, they can just lie in wait and then gamble on their appeal and get the most favorable standard of review possible to try and overturn their conviction. This incentivizes gamesmanship, and this court should just stick with the current standard.
No, go ahead.
Could I ask you, back you up to 6404?
Yes.
Seems counterintuitive to me that we would say that if we have prosecutorial error, no objection is required to raise it. So if the prosecutor causes an unfair trial, you can raise that for the first time on appeal. But if the judge does the same thing, that they can't raise it. I mean, what's the difference in the prosecutor adulterating the trial and a judge?
I think that's actually a reason to change the prosecutorial error standard, not change the judicial misconduct standard.
How would you handle cumulative error if you have burdens on a case where you have burdens of proving harmlessness on different parties for the individual errors?
I think you kind of do it the same way we do when there's a constitutional error and a statutory error. You use the strictest error standard and say that's the one you have to meet because there are multiples.
Well, that is what we do, but that doesn't address the burden. Who should have the burden?
Right, but I think you could essentially do it that way too. You say, well, state, you're going to bear the burden because there are both preserved and unpreserved issues.
So then it does shift? Once you have another error,
I'm
it
trying to
magically
think.
does shift?
In the cumulative error, yes, it would.
So if a defendant was,
I think
put the word fortunate in quotes, but if a defendant was fortunate enough to have another error, then it's okay to put the burden on the state to show harmlessness of a judicial
think we haven't
error?
asked to overrule the cumulative error, and the cumulative error rule currently requires the state to prove it is harmless. You could attempt to say, well, they didn't meet their burden here, and the state didn't meet their burden here, and do some kind of.
Are we mixing up clear error or plain error and harmlessness? Aren't those two different things? I mean, the cumulative error test is a harmlessness test,
Correct.
right?
Correct.
And when we talk about unpreserved error, and then we're going to apply some kind of a heightened standard, a clear error or plain error standard, we don't then move to a harmlessness analysis after that, do we?
No, and in fact, this court already, with jury instructions, does the cumulative
So if
error
we
analysis.
find that there is a plain or clear error, it's a reversible error, right? There's no
Right.
harmlessness inquiry that comes after that.
Oh, correct, Your Honor. Yes.
So I guess I don't understand how this question of plain error or clear error gets mixed up with cumulative error, which is a pure harmlessness
I don't
question.
think it would, because if there was plain or clear error, you wouldn't have to get to the cumulative error analysis at all.
And if there's not, it doesn't go in the bucket of potentially harmless or harmful errors.
Correct.
Do you see a difference in the judicial misconduct being unpreserved versus other kinds of errors? The notion that it sets a different tone, or it's a different type of calculus that has to be given to defense counsel or anyone else who claims the judge made an error, as opposed to another party making an error?
I agree that it might be more difficult to object when a judge is, especially the judge you're appearing in front of, is doing something. I don't think that's this case. I think it would have been really easy to fix this particular error.
So in this case, the counsel should have got up and said, "Judge, I object. We're going to have to start this case all over. Case is contaminated by this error," pointing more attention to the mistake of saying it's an aggravated battery.
Well, the judge could have also cured it by saying about the presumption of innocence, I was mistaken. He could have he did here say, let's start over, which I think was an attempt to say, ignore everything I just said and start over here. I think there are other ways to fix it. They also could have, it was just half the jury panel at the time. They could have excused those panels and done with the other half and see if they could have done it without a mistrial. But I do think that there, even with judicial misconduct being an allegation, I think that's the reason we allowed you to reach it for the first time on appeal. You shouldn't get a more favorable standard of burden error too, but you should be able to reach it. That's what I think the concession to the defendants is. Fine, you didn't object, we can still reach it because of how difficult in some circumstances it could be to try and accuse the judge or appear in front of committing error.
What we're really talking about here, it seems to me, and I want to ask if you agree, is not changing the burden of proof, but is instead reevaluating whether or not we require an objection to preserve the question for appeal. Isn't that the fundamental question that makes the difference here?
Right, if you're...
Because if we are going to say there is no, just as in prosecutorial error, there's no obligation to object in order to preserve, now all of a sudden it is a preserved question for appeal. And then we go to our ordinary harmlessness type analysis, which does put the burden on the state, right?
Right. I still think, and I'm going to argue in my next case, that I don't like the prosecutorial error being unobjected to either. But I think you can still have the very test you have, which do you allow them to raise it for the first time on appeal, but
right,
it's
but
their
where the roads diverge is at the point at which we require an objection or not.
Right.
That's where the analytical roads diverge.
Yes, Your Honor.
Is there, go ahead.
Go ahead.
To go back to an earlier question to follow up on it, is there a difference between prosecutorial error and our standard for that, which I know you don't like? When a prosecutor makes an error and we basically say because the party benefiting from the error, i.e. the prosecutor's own error, we're going to put the burden on the prosecutor to prove harmlessness. On the other hand, we have a judge who made an error. The prosecutor had nothing to do with it. And we would have a different standard or burden on appeal. In other words, the state would say, we didn't cause this error, Judge, you did. And why should we have to prove harmlessness? I'm just asking, is that a distinction without a difference, or is that important?
That could be another distinction that this court's had, just like it's difficult for a defense to stand up sometimes to the judge. It's equally as difficult for the prosecutor to point out error. And so maybe that's why the defendant has to bear the burden, if you don't want to change the prosecutorial error standard. I think there are multiple different reasons that this court should just basically abide by stare decisis and keep the rule that is currently in place for judicial misconduct.
What, in your view, what is the difference between the second exception that we have of our three exceptions for raising an error for the first time on appeal? That is the exception that it would serve the ends of justice or there's been a denial of a fundamental right. What's the distinction between that and the plain error standard of under the federal case law as you see it? Or is there any?
I'm not entirely sure if the federal standard is, and Corey quoted it in his brief.
Yeah, I think it's usually which affects substantial rights.
Right.
Or they have a fourth factor which seriously affects the fairness, integrity, or public reputation of the judicial proceedings.
Right, I think they're similar. I'm not sure off the top of my head if there's a way to argue that they're substantially different. I do think that's why the reason that error is allowed to be reached, I don't think if this court were to adopt the plain error standard would be you'd be reaching any less cases. So I think they probably are about the same.
Do you have any further presentation?
I was actually going to talk about the other issue. Sorry, I just want to make sure there are no more questions on that issue. On the jury nullification issue, I know I've asked this court to overrule Smith-Parker. I don't think you necessarily have to do that to get here, but I do think the defendant's argument, which is essentially it goes too far if you tell the jury to follow the law, comes from Smith-Parker. And to the extent that that's right, Smith-Parker should be limited or overruled. But regardless, this court's decision in Lanahan and Naputi basically say you don't get a jury instruction on jury nullification. There's no reason this court should change that longstanding precedent. And the jury, in multiple times in the defendant's brief, they said the right to jury nullification. There is no right to jury nullification. Jury nullification is a raw power possessed by the jury. And as Justice Johnson pointed out, it is a power that exists when there is a mandatory requirement. You're told to follow the law, you decide not to. That's jury nullification in essence. In fact, this court basically said as much in State v. Robinson when they said, I'm sorry, I thought I heard something. No, when the court said telling the jury to follow the law does not preclude jury nullification. That's pretty much what they said. You should hold the same here. There is no error in this case. This instruction is fundamental. It is absolutely necessary. I cannot see a way to protect the defendant's rights without this instruction.
Wasn't the language in Smith Parker, you will do something rather than must? It was slightly different, wasn't it?
I will trust your memory on... Yeah, it says you will enter a verdict guilty, correct.
I don't know. To me, just as a matter of English and understanding the meaning of the word, will seems to assert a type of authority over decision making that telling somebody they must do something doesn't. You can say to it, I think of telling a child, you will sit down, as opposed to you must sit down. The child seems freer to disobey in the second.
And I'm fine if this court wants to say you can't say will and must is fine, but in which case Smith Parker did overrule Lovelace, which did say that must was okay. So if we could at least go back to Lovelace, that would be good.
Okay.
If there are no further questions, I respectfully ask that the Court of Appeals be affirmed.
Any more questions? Thank you, counsel.
Thank you.
May it please the court. As far as the game, on the first issue, as far as the gamesmanship, that the attorney can just put some judicial misconduct in his pocket, it seems like the prosecutor is down there too. And currently the defendant has a motive to try and correct the judicial misconduct. That could be affecting the jury, he could lose his trial. It's not bad for the prosecutor to have some skin in the game too, maybe. To think that they see the judicial misconduct and they know, okay, I'm gonna have to show this is harmless. They have something as opposed to, hey, cut a break there. We'll just.
Didn't the prosecutor here actually?
Yes.
Try to keep, well, maybe not cure, but at least address the court
Certainly.
as to the mistake.
That's absolutely
Is there
right.
any burden beyond that?
Yes, I think it's. I think, and the prosecutor certainly was the one who pointed out that was incorrect, Your Honor. But I think you need to go on. The problem, I guess, the prosecutor pointed out that the judge said aggravated battery and aggravated battery instead of aggravated burglary, and if the judge would have said, "Oh, okay, let me start over," okay, that's not a problem. People misspeak. I misspoke at least once while I was up here. That wasn't the error. That wasn't the misconduct. The misconduct was when the judge then said, "Oh, I'm thinking of his other case," which nobody addressed that. So the prosecutor absolutely stood and said, "Oh, judge, that's wrong," which is great. That's what we want, right? And that wouldn't have. I don't think I'd be standing here if that was the end of the discussion.
Do you think, the other thing I thought about this when you're part of your problem with saying that it's an aggravated battery was lent more credence to the fact that your client may have been pointing the gun as opposed to not pointing the gun. Do you think most people think that when they hear the words aggravated battery, it necessarily includes a gun? I mean, we lawyers definitely think that. Don't you think it means he was beat up real bad?
Sure, it absolutely could have been. But I think in addition to the gun, that he had a gun, and that would prejudice the jury, I think you also have just the idea of how violent a person is this guy? Because part of it is the fear. Was he in reasonable apprehension of fear? And how violent was this man? Because he has a gun, and so he has another case. He's been charged with another case with aggravated battery. Even if you believe, okay, he beat up somebody really, really bad, that's still 455.
Well, I'm just being, but I don't necessarily would imply that because a layperson hears the words aggravated battery, that necessarily would include a gun, and I thought that's what you were saying.
Yeah, if I limited it, I hope I didn't limit it to that. The idea was that he was a violent person, and the jury could give that any kind of weight.
Counsel, before you sit down, could you address why this is reversible error? The cumulative error argument?
On the judicial misconduct.
All the errors that you've alleged.
Sure.
Why
Yeah.
should we reverse this?
Yeah. Well, I think the on the judicial misconduct, what we're talking about here, the issue was this person in reasonable apprehension of bodily harm? Because he reached in and grabbed the gun. I think there was some question about whether the gun was pointed to him or not. So the jury had to decide sort of what kind of man was Christopher Boothby, as far as whether the person was, whether the cousin was in reasonable apprehension of bodily harm. And knowing that he has this other case out there, I think that is a problem. It's much akin to 455 evidence, which this court is let's just shew up with no instructions. So that's on the first issue. Frankly, on the second issue, harmless error on nullification, I think, is going to be a tough row to hoe, because the essence of it is that the facts and the law are that the jury disregarded the facts and the law. The jury found that he committed these crimes, but for some reason did not do it. And I think that's going to be tough without something in the record. It's going to be difficult a lot of times to establish this. Nonetheless, you do have in this situation where the cousin went up to the truck. They argued, they wrestled around. Could be the jury said, yeah, he was afraid, but this isn't really what we consider aggravated assault, which is, I think, the essence of it. This isn't what we consider to be an aggravated assault.
All right, thank you, counsel.
Thank you.
Have any more questions? Thank you both for your arguments this morning. Court will take this matter under advisement.